All right, we're going to get started here. Thank you for joining today's presentation, brought to you by the SLW Institute, which was developed by the Schwegman Law Firm to deliver educational and training content to advance your IP knowledge. My name is Brian Ness, and I'm facilitating this webinar series. Before I talk about this series in today's presentation, here are a few housekeeping items to keep in mind. If you have any questions during today's presentation, we encourage you to use either the Q&A or chat feature. Also, we'll be sending a follow-up email to each of you tomorrow that provides a link to the recording of this webinar and a copy of today's PowerPoint. In this particular webinar series, which is presented by the Schwegman Chem and Biolegal team. Their goal is going to be to provide practical tips to companies and universities looking for an understanding of a new era of patent law to protect IP in chemistry, pharmaceuticals, biotech, and genetic medicine. For today's presentation, Dr. Jim Nelson and Ryan Connell will provide 5 tips on patent prosecution for polymer technologies. Jim and Ryan, I'll let you introduce yourselves and take it from here.
Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast. And I hope those of you in the Midwest are enjoying lunchtime. This is Jim Nelson, and Ryan and I will present a seminar today about that dirty, nasty little word, comprising in patent claims. I am a senior partner at the Schwegman firm with over 40 years of experience in intellectual property. I was a medicinal scientist for Pfizer and then became a patent attorney there. I joined the Kenyon law firm in downtown Manhattan and practiced there for quite some time, and then rejoined my colleagues out here in the Midwest and have been practicing in the Midwest with our firm, the Schwegman firm, for a number of years. Ryan?
Well, thanks, Jim. And yeah, my name's Ryan Connell. I am an associate here at the Schwegman firm. I joined here just about 2 years ago or so after practicing at another firm here in Minneapolis. Before going into law, I studied chemistry, ultimately getting a master's degree with a emphasis in organic synthesis for small molecules relating to anti-cancer applications. And I've really been enjoying my practice here, and I'm looking forward to conducting this seminar to talk about comprising as it relates to polymer technology. So with that, let's get into it.
That word comprising, of course, is a transition phrase. It moves the claim from the preamble to the body of the claim, and it's got special legal connotations and in the law, especially for patent law. And Ryan will explain the traditional understanding of comprising.
Sure. So as we know, when we use comprising in a claim, that transitional phrase, of course, opens up the claim to read on embodiments or other devices or what have you that go beyond that which is explicitly recited in the claim. That is, you of course have to have each feature that's recited in the claim at a minimum, and you open yourself up to potentially read on things that include those features plus other things. And of course, we're all very comfortable in our practice using comprising in our day-to-day, and we understand the metes and bounds of what our claims encompass when we do use that. Now, one of the things that we want to discuss in this seminar, however, is the potential differences that term can have in terms of how it applies to chemical claims as opposed to electromechanical claims or really other arts.
So Ryan, as I remember my initial training in intellectual property law, that word comprising meant that if I have a claim that reads a composition comprising ingredient A, and somebody else comes along and mixes ingredients B and C with ingredient A, that person would still be infringing my claim because he has a mixture of A, B, and C, and you can find A in this mixture of B and C. That's the traditional understanding of comprising, correct?
That is completely correct. As long as you can find and isolate A, then you should, by the definition, be able to read on that claim. And that's how we understand that to work in the vast majority of contexts, including in a electromechanical claim, for instance. Here, just to illustrate, of course, I have a rather broad claim, but good for demonstration purposes here, where we have a receiver that includes a amplifier. Now, this claim should be able to read on almost any other device that includes an amplifier that's connected as we have it in the claim. So if we look at other examples as far as what this could read on, we can envision a whole host of devices that at a minimum include an amplifier, such as an Apple Watch, a guitar amplifier, or a hearing aid. All these would meet the basic limitations of that example claim I drafted, even though it may be directed towards something as complex as a interstellar receiver. Essentially, what's going on with these and Jim's example that he mentioned with the compositions is that you have here an amplifier that's a discrete fungible item that you can essentially find, isolate, remove, and apply to any other device without, I suppose, damaging the amplifier, changing its function, or anything to that effect. It's truly something that's fungible.
So, as I understand it, Ryan, if I have pearl beads and I add sugar and sodium chloride to this mixture, and I have a claim, a composition comprising pearl beads, the person who's added sugar and sodium chloride to these pearl beads would be infringing my claim because it's just a simple mixture, correct?
Well, now that depends. It can depend very much on, now that we have a chemical feature there, it depends on, for amongst other things, whether that sugar, for instance, or salt is actually bonded or adhered to that pearl bead. And that's where you might not find that your pearl bead is fungible in the same sense that the amplifier in these examples is. So maybe to illustrate that, let's look at some chemical cases here. So chemical structures can be a little bit different, as we alluded to with this pearl example. As an example here, suppose that we had a claim that was directed towards a composition that comprises a benzene. If we look at that claim as far as the scope that we can apply it to read on other compounds, some interesting questions arise, such as can we have that claim read on a naphthalene or benzoic acid, or really any other compound that includes at least a six-membered aromatic ring? Well, it appears that you can find the benzene. The question is, can you actually isolate it in the same way that you could my example amplifier? Well, the answer is no on that one. If you were to take naphthalene, for instance, and try to pluck out or remove that benzene, you would break the bonds. You'd have terminal end valences. Wouldn't have the ring anymore. It just would be a very different molecule, and it's not as easy as saying I see benzene in that molecule, therefore my claim to benzene would read on it.
Ryan, let me see if I understand this. I think it follows along what Judge Laurie said in several of the Federal Circuit cases, for example, in Ray Swanson, where he said when you write a chemical structure on a piece of paper, you're just drawing lines on the piece of paper. That's not what the compound really is. It exists in a beaker. It exists in a pill. It's real. It's functional. It has certain properties. So to think that you could take that naphthalene molecule and pull out from it this benzene ring is absurd, because those carbon atoms in the naphthalene no longer describe the benzene. Those are completely unique and different entities. Now, I think what he was saying is, not only do you have the chemical structure indicated by the carbon atoms, and it's an aromatic structure where the electrons are in a pi formation, and pi rings around the nuclei, but he was also saying that properties are important for this kind of claim, for this chemical claim. Can you tell us a little bit more about these properties? What did he mean by properties?
Well, of course, and that dovetails nicely too to the foundational In re Papish case from the Federal Circuit predecessor, which said that a claim to a compound or structure is not just structure but also to its properties. And looking at benzene and naphthalene, for instance, we know that at room temperature, the benzene exists as a liquid, whereas naphthalene exists in a solid state. So to try to equate these two, or to think that you could simply remove the benzene the benzene functionality from that naphthalene, it doesn't work that way, because not only are you having a different structure, but the properties between these two are very different. So it's hard to say that a claim to benzene reads on naphthalene when they're truly completely different, by both in terms of structure and in terms of property.
So this sounds like saying that a wolverine is not a bear. And now we know that wolverines and bears are of the same generic family, but a bear is big, a wolverine is small, a wolverine is fierce, a bear is not so fierce in ordinary circumstances, and they are different animals. You can't find the wolverine structure in the bear or vice versa. So for the naphthalene and the benzene, you know that naphthalene smells like mothballs, and benzene has a peculiar aromatic odor. I think those of us who are older former chemists remember pipetting benzene by mouth and getting that acrid taste in our mouths. Of course, we don't do that these days, but very, very different properties. You can't say, like you can in many electronic and mechanical situations, you can't extract parts out of the whole.
Exactly. And this is in the context of a small molecule too. And if we look and apply these teachings to a polymer structure, we see that the same principles apply. For instance, if we have this first polymer structure here with the N and the M monomer, if we wanted that to read on that second structure with the N, the M, and the O monomers, again, you run into those same problems, that these are two different structures, even though it appears that the N and M monomer appear in the second structure. It's not simply a matter of plucking out the N and the M to have your claim read on that. You have completely different structures, completely assumedly different properties by virtue of that third monomer in there. And so you have to really be careful when you have these claims to not overestimate how much breadth you're bringing in when you use comprising.
Now, in this slide, we're looking at polymers, and polymers are unique because although we've been talking about single entities in terms of benzene and naphthalene, every molecule is identical. Polymers are not that way. Polymers typically are assemblies or mixtures of the polymer polymerized monomers, and these individual molecules have molecular weights that range in a Gaussian manner from small to large molecular weights. So even if we had a single monomer like styrene or like methylstyrene, and we polymerized it, my guess is, and you tell me if I'm right or wrong about this, Ryan, my guess is, depending on even the molecular weight and the molecular weight distribution, we'd have different properties that would be so substantially different that a polymer, polystyrene of low average molecular weight, would be very different from a polystyrene of high molecular weight. Is that right?
Well, certainly. And that's why, beyond just claiming, your structure like this too, that's why oftentimes in the polymer claims we try to give a range of weights, weight average molecular weights, that is, of the polymer, to try to hone in on those, on what variety of the polymer you actually want to capture.
It sounds like you need to put in more information about these products than just simply drawing the structure. It sounds like we need a more complete written description, and it needs to be expanded to cover all the variations that you might imagine, right?
You're 100% correct. And really, to get the most out of the word, out of the transitional phrase comprising, not only do you want to be aware of how much detail you want to put in to give the breadth of interpretation that you want, but you also need to be cognizant on another angle as far as if you're putting in enough detail to at least overcome sections or troubles associated with Section 112, written description and enablement. And I think you've pointed out some, or have some stuff to say about this claim in that respect.
Well, this is a claim from a patent that was litigated quite some time ago. It's a claim to a high molecular polymer, and it's a comprising claim. You can see the word comprising in the second line, and stripping out a lot of the detail. It's a polymer comprising a copolymer or homopolymer of two monomers, and then there's a third ingredient here, the low molecular compounds. And a compounds, that word is plural, so it must mean, at least that's what it seems like, it must mean that there are other things, not a single thing, but other things, low molecular weight compounds, present in this polymer. So here we have a polymer comprising a copolymer or homopolymer of two monomers. So this seems on its surface to be a fairly reasonable, well understood claim, but let's parse it out and pull it apart to try to figure out what we're talking about here. Well, okay. First of all, looking at the body of the claim, we've got a copolymer or homopolymer of lactic acid and glycolic acid. Well, what does that word copolymer mean? What does that word homopolymer mean? And homopolymer, to me, just looking at the word in the claim, means it's a single monomer. Copolymer, looking just at that word in the claim, means it's got two monomers in it. But of course, in the specification, the patent drafter may want to expand on those terms. Here is another point about written description. You would want to explain in detail that your copolymer could include 2, 3, 4 other kinds of monomers in addition to the two that you have listed here. Well, in addition to that, we know that we've got the word polymer, and that is the seminal word describing what we're trying to claim. It's a polymer, and it at least has this copolymer or homopolymer in it. Well, does this mean, based upon our understanding of comprising, that we could have other things in the copolymer and homopolymer to make it the polymer? Because, of course, that's what comprising means. I at least have the things expressed in the claim. In other words, ingredient A and ingredient B, that's the copolymer or homopolymer, and I can add other things to it. Wait a minute. Does that mean that I could add other hydroxycarboxylic acids to this? I could add other dialcohols to this. I could add other diacids to this. I could add amino acids to this copolymer or homopolymer, and I'd still be within the scope of this polymer? Well, this claim says nothing about that. What does it say about this kind of addition product in the specification? If nothing is said, does this claim read on those kinds of materials where we have additional C, D, E, F, G, H, I, J kinds of ingredients added to the copolymer or homopolymer in a reactive fashion? Remember, we said that a claim to benzene does not cover naphthalene. Similarly, a claim to a copolymer or homopolymer without further description doesn't mean that you've got a polyester polyamide present. So what's the problem with expanding the claim to that extent? What do you think, Ryan?
Well, the problem is, and the problem is, as it's written here, we don't know that we can support that. It's an issue. It's akin to when you're thinking about 112 in written description, what exactly do you have support for in your specification? And if you're going to try to expand the scope of this claim to cover all these different variations, it's really a question of, do you have support for that? Are you able to actually bring that and capture that with your claim? And not only is that present here, but it really manifests itself in the realm of biopolymers, such as your proteins or others. In particular, if you think about if you had a claim to a protein, an enzyme, for instance, and you wanted to claim it by its active site, you could have some problems if you just recite the structure around there as far relating to capturing the balance of that protein.
This reminds me of the developmental days of biotechnology back in the late 80s, early 90s, when the Cohen-Boyer process became the functional and fundamental basis for developing new kinds of biopolymers, new kinds of proteins. And in those days, people would try to claim what they called ESTs. They were snippets from a gene or snippets from a protein that could be the exon of a particular genome, or it could be the epitopal site of a particular active protein. And they would claim, say, if it's a peptide, a polypeptide, they would claim a 10-unit polypeptide and say that they were claiming a protein comprising this 10-unit polypeptide. Well, wait a minute. The protein that they describe in the spec is maybe 20,000 molecular weight units, 20,000 Daltons, and yet they're talking about a protein that's only 10 units, I mean a peptide that's only 10 units long. And of course, those kinds of claims got slapped down very quickly by the Federal Circuit and by the Patent Office because they weren't satisfying the basic requirement for chemical claims, and claims to peptides, claims to nucleotides, claims to polymers, claims to polynucleotides are all chemical claims. They have to be claims that describe the sufficient enough structure to understand what you're talking about and the properties. So if you have this 10-unit peptide, you can find that 10-unit peptide in many, many kinds of proteins. Say it's a polyglycine. You can find that polyglycine in many kinds of proteins, for example. And does that mean that any protein with a polyglycine, or let's say it's a combination of glycine and leucine and a valine, does any protein that has those 3 amino acids in a 10-unit form, does any protein with those motifs, are they covered? And the answer is, oh, this is crazy. This is nuts. And so that is the problem with this dirty little word, comprising.
Exactly. Really, it's a two-pronged issue that you can get in terms of how much coverage you are entitled to, whether you think if you're getting as much coverage as you may think you are, and then also the whole host of issues that can be opened up in terms of written description enablement. And I think, with that, we'll get to some tips to keep in mind as we deal with that word comprising in terms of polymers. And again, it's really, I think, one of the take-homes with this is, it's fine to use, but if you do use it, you really need to write your specification or include dependent claims with this in mind to really establish the bounds of what you want comprising to include.
So Ryan, I think you're saying that don't use this word comprising as a shorthand technique. Exactly. Where you have a certain motif or a certain quality of one particular compound that you've identified, and you want to expand your claim scope to cover a multitude of possibilities. Don't use the word comprising as a shorthand way to do this. So don't use it, say, a protein or a composition comprising this little snippet, and I cover anything that has this little snippet. In other words, our benzene versus naphthalene situation. Instead, Ryan, aren't you saying that you need sufficient written description and you need to use different words as generic words to describe that generically would encompass all of these things, and you need to provide detailed description of all these variations? Isn't that correct?
That's entirely correct. It's not enough just to use comprising and expect comprising alone to do the work for you of giving you the broad coverage that you seek. You need to really pay attention as you're drafting this to lay out the boundaries of what all you want to be encompassed there. And Jim's absolutely right to use as generic a term as you can, and then to really build on that as far as what you can envision your claims reading on. And that's of course difficult when you're given a disclosure it's hard to have a crystal ball and see where the future is going and what you want to cover. But that's where it does take a lot of work on the front end in the chemical arts to make sure that comprising is in fact doing what you want it to do.
So that's the problem with our claim from this litigated patent, where the patent attorney attempted to use this word comprising and the generic word polymer as a shorthand method to cover all sorts of things. For example, polyesters, polyamide esters, and on and on and on like that, rather than describing all those factors and features in his specification and in the details. So what's a take home here? Don't use comprising as a shorthand method. Instead, you're faced with this patent attorney dilemma that we all have. How do we attempt to claim something that would incorporate our client's invention, but yet our client has not contemplated specifically yet? And of course, that is the extrapolation and crystal ball gazing that patent attorneys often do. And don't fall into the trap of thinking that comprising will take care of these issues. Think about written description. Think about providing all the different motifs that are necessary in order to incorporate and encompass what it is you're trying to cover.
And with that, I think we will take questions and open it up for discussion.
Sounds good. Looks like we have one question here. If you guys wouldn't mind taking a look at that, we'll give the rest of the audience a minute or so to funnel their questions in to Jim and Ryan via chat.
So the question here is, wouldn't mole percent limits of 100 to 0 make it a homopolymer versus 50-50 make it a copolymer, and everything in between? You bet. 110%. That's right. But the question is not whether the claim is directed only to this homopolymer of either lactic acid or glycolic acid, or a copolymer of only lactic acid and glycolic acid, but would the polymer, not the homopolymer or copolymer, would the polymer, in other words, the preamble word, would that encompass things that are more than simply polylactide glycolide as a copolymer, or polylactide as a homopolymer, or polyglycolide as a homopolymer? In other words, could we add glycine to this? Could we add adipic acid to this? Could we add hexane diol to this? Could we add any number of diacids? And there's just no disclosure. So that is the problem. And of course, that is what the patent attorney who drafted this claim was attempting to do in a shorthand way. Oh, I'm going to use this word polymer to cover things that I can't conceive of right now, but my polymer at least has this copolymer or homopolymer in it, but it's got other things in it too, and I want to cover those, but I'm not going to tell you what they are. Well, wait a minute. That's a real problem. I'm not going to tell you what they are. Exactly. That's almost like a reach-through claim. It's not a reach-through claim because it at least doesn't involve a biological mechanism, but at the same time, it fails 112 because it lacks written description. You don't know what he's talking about. That claim fails 112 because it lacks written description. You don't know what other things are included.
Exactly. Yep.
Thanks, Jim. Want to remind everyone, we'll send out a copy of the slides and a recording of today's presentation tomorrow. You should get an email about that. For the next presentation, that's going to happen on December 14th, U.S. versus International Claim Scope and Application Support. Also, I wanted to remind everyone that we do have a blog that's dedicated to, next slide, Ryan. IP law blog that's dedicated to biotech. Warren Worcester, one of our founding shareholders, heads this blog, does a great job on it, has guest speakers from our attorneys and others around the industry. So go ahead and check that out if you're interested. Thank you again to Ryan and Jim, and I hope everyone has a great day. Thank you.